My name is Libby Clarkson and I'm an associate in the Planning and Development team at Rollins. Today I'm going to discuss Section 106 agreements and some key points which should always be considered. We all know that when drafting Section 106 agreements, the agreement has often taken a very long time to materialise, and so it's often tempting to complete the agreement as quickly as possible without reviewing the detail so that the development is not held up any longer. However, there are a number of important factors which must be considered before a Section 106 agreement is completed, otherwise there is a risk of the agreement being invalid, incorrect costs being paid, or delays when the land or any residential plots are sold in the future. The first key point to consider is the land ownership and any interest in the land. The title to the property should be considered, and all landowners and parties with an interest in the property should be a party to the agreement or grant consent to the agreement, depending on the nature of the interest. This includes any lender, tenant, or any other party with an interest in the land, such as an option to purchase. Next, the detail of the agreement should be checked carefully to ensure the plans, drawings, and financial contributions are correct, as it is surprising how often incorrect information is included when the agreement is first drafted. The trigger date should also be reviewed to ensure that funds are readily available when due, and the dates diarised to ensure they are met. Another important point to consider is that the agreement should expressly state that the Section 106 obligations will only come into force upon implementation of the planning permission and not upon signature of the agreement or upon the grant of planning consent. The agreement should also include a provision stating that the agreement will cease to apply in the event that the relevant planning consent is quashed, varied, revoked, or otherwise comes to an end. If the planning consent is for residential development, a clause should be added to the agreement providing that any plot purchasers shall not be bound by the Section 106 agreement if this can be negotiated with the relevant local planning authority to assist with the plot sales going forwards. If the property is subject to a legal charge, the agreement should include a mortgagee protection clause which states that the mortgagee will not be liable for any obligations under the agreement unless and until they take possession of the property. The wording of this clause is extremely contentious, and the exact wording should be carefully checked with any lender or registered provider to make sure that they are happy with the proposed wording. Equally, any affordable housing provisions should be reviewed in detail and signed off by the registered provider if they are known. The agreement should also provide that any protected tenants and their mortgagees shall not be bound by the terms of the Section 106 agreement. If the provisions are not signed off by any interested party, then there is a risk that the agreement may need to be varied later down the line, which could lead to delays and additional costs. Finally, where a landowner is entering into an agreement where there is a developer on board, an indemnity should be sought from the developer in the relevant land agreement for any contributions contained within the agreement and for any costs or claims incurred by the owner in the event of a breach of the agreement by the developer. I hope this vlog has been useful, and if you have any questions or comments regarding any of the points raised, then please contact me and I will be happy to assist.